So I like to start out these things. I've done this a few times for different organizations, and I like to start out this presentation by saying, do you remember the episode that we had? It's been nearly 20 years ago now, but there was a lady in Florida who had been incapacitated for quite some time because of a medical condition, and she did not have a healthcare power of attorney. She did not have a living will, and her husband and her family, her mother and father, got into a very nasty fight over how her medical care should be handled. And in fact, their family became the focus of all these national news reporting on all the big cable networks. And I don't know if you remember this or not, but Congress actually went into session over a weekend and attempted to pass a statute that instructed the state court judge in Florida about how to handle the case. So if you would like to become a focal point of all the ill will that the national news media feel for various segments of itself, then don't do any of these things, because maybe one day it'll blow up in your face. But that's a very good reason to do it. The other thing is not the other thing is not really that big, but this is a thing that's basically consideration for your family. If you don't have a power of attorney in place for someone else to be able to act on your behalf, and you become incapacitated through a medical condition, through an automobile accident, through any other source, you may end up costing your family additional money, because they'll have to go to probate court and see Judge Hudson or Judge Childress and ask for a conservator to be appointed to make decisions on your behalf. You can handle these things privately, and that gives you a lot of power in two ways. Number one, you can define exactly what you want the scope of the person's authority to be. And number two, you can define the first person that you want to do it, the second person that you want to do it, and even a third or a fourth person that you want to do it. So you can be in complete control of how these things will go. So here's a little bit of basic explanation about what we're doing. A power of attorney is basically a document that allows one person to act for another. So if my mother has a bank account and she needs me to make a transaction for her and I'm not signed on the account, then generally I cannot do that. But a power of attorney is a document that says, my mother is authorizing me to act on her behalf. And so I can take that document around with me and I can use it to conduct business on behalf of my mother. A living will is a document that really specifically addresses that Shivo situation that happened in Florida. It's a document that says, to my doctors, to my medical providers, here's what I want to happen if I can't make crucial medical decisions for myself. If I'm unable to eat, do I want to be fed intravenously? Do I want to be fed by a feeding tube or not? If I am unable to regain consciousness, what level of medical care do I wish to have? And so it's basic planning documents, and they, one, make your wishes known to people in advance right now while you can think about it. You're clear-headed and you can think about it. You can write down what you want to happen. And number two, you can pick the person who you want to make your decisions if you can't do that for yourself. Okay, next slide, please. It doesn't have to be that you're going to be necessarily unconscious. It may just be a matter of convenience. Like the example that I gave with my mother, she may not feel like leaving the house that day. Or think about the last year. My mother's 85 years old. And so over the last year, at times, she hasn't wanted to leave the house to conduct business on her own behalf, so she could have myself or my sister or my brother do that in her name, do it for her so that she doesn't have to leave the house and go out into public. So it doesn't have to be that you're unconscious or medically incapacitated. These things work when you're just doing it for a simple matter of convenience. Let me tell you where I learned about this a long time ago before I was ever on deployment. In 1989, after I graduated from college, I graduated from the basic school at Quantico, and I was at my first duty station at Camp Lejeune, North Carolina, and I was scheduled to go on a short deployment, only about a month long, to South America, to Colombia. And my commanding officer came out and he said, okay, everybody who doesn't already have one needs to go to we had a legal services office, and get a power of attorney and a will done. I had no idea. I'd never thought about either one of these things. I was 23 years old. I thought I was going to live forever and nobody could harm me. And so I hadn't even thought about these things. But I did have a brand new wife at the time. We'd been married about 2 months. And you can see where if she'd need to do something while I was in South America, it would have been very, very difficult for her to get it done. And so I've been thankful to that gentleman who forced me to go and get that done at this early age when I started thinking about it. It would be highly inconvenient for her to have tried to get that done without me there and without this paper that she might have needed to do some banking transaction or insurance transaction. People most often pick their spouse or their child to act on their behalf. Now, it doesn't have to be a spouse or a child. It can actually be anyone. It could be any third person. You could pick but I'll tell you one thing, pick someone that you trust. Because once this document has been signed by you, it gives the person a world of authority. In the case of healthcare, it gives the person the right to make life and death decisions on your behalf. So don't pick someone lightly. Pick someone that you trust, someone who you know will hold your best interest at heart. You can go to the next slide. I just reiterated that on the top of this slide also because it needs to be somebody you trust. Once you give somebody one of these power of attorney documents, that person has something called a fiduciary obligation to you, which means that that person has a legal obligation to act on your best interest, not on what would benefit them, but rather on what would be in your best interest. The problem with that, as I've discovered over the course of 25 years of practicing law, is that people don't often have a very clear understanding of what it means to have a fiduciary obligation to another person. And so you need to be careful when you pick somebody because of the power that it gives them. Next slide, please. I just wanted to cover a little bit of terminology. There are two other things that go along with this. Number one, we're going to talk about durable powers of attorney. And what does that mean? That just means simply when you see that name applied to it, it just means it doesn't stop if you become incapacitated. A long time ago, 45 years ago, there was a court case that said these things stop being effective if the person becomes incapacitated. So now we have a statute that says if the power of attorney says that it's durable, then it does not stop if the person becomes unconscious or incapacitated. The other thing may be, and this doesn't necessarily apply to healthcare powers, but only to the general kind of powers, you may see the word springing. And a springing power of attorney is one that comes into effect at some later date. In other words, I may sign it today, but it only becomes effective if I'm unconscious or if I'm incapacitated. Now that applies automatically to healthcare powers, but with general business powers of attorney, you have to put the word springing in there for that to be effective. Okay, next slide, please. So the next thing that we're going to talk about is the first kind, which is sort of a general personal business power of attorney. This is something that we often call a durable general power of attorney, but it can also be called a durable limited power of attorney. And I'll bet that a lot of you may have had experience with this, like in a real estate closing. If my wife and I are purchasing a home or selling our home, and it turns out that I'm going to be out of town on business that the day people have got selected for their closing, I can give my wife what's called a limited power of attorney, and she could go and sign all the documents at the closing for that real estate transaction. That is a limited, means it's only for that specific purpose, whereas general means that it's for all purposes: banking transactions, property taxes, signing all kinds of deeds, even ones that aren't specifically set out in the limited power of attorney, signing contracts, paying taxes, things like that, filling out tax forms for the government, anything. All those things can be done under a general power. Under a limited power, it's going to say specifically what it's for in the document, and it can't be used for anything else. Okay, the next slide, please. The next kind is a healthcare power, and this is basically a document that gives a right to person to obtain medical treatment, obtain medical records. It's often called a durable power of attorney for healthcare. And I say again, it's very important to remember that this document is going to give that person that you name in the document the power to make healthcare decisions on your behalf if you can't make them for yourself. So if you're involved in a serious automobile accident and you're unconscious, you have, let's say, something very dire like a fractured vertebrae, and you're unconscious because you took a good lick on the head, and you're in the hospital and you can't communicate with your medical providers, then the person who has this durable healthcare power on your behalf can come to the hospital and make these decisions on your behalf. Now, two things about this. Number one, if you have a spouse, medical providers generally will accept the decision of your spouse, even if you don't have one of these power of attorney documents. But if there's a disagreement, for example, between your spouse and the rest of your family, and there's not one of these documents, then you're going to be in the situation that Ms. Shivo was in Florida when the dispute occurred between her husband and her parents. So these things are very, very useful. The only other way that a person can make healthcare decisions is to have a judge appoint something called a conservator. And that is a very expensive, time-consuming proceeding. You have to have doctor affidavits. The person has to have a lawyer appointed on their behalf. The judge has to have a hearing. It takes quite a bit of time. It's a difficult process. And this healthcare power can cut off the need for that to make those healthcare decisions. If you go to get one, you're going to have this warning, which is in the next slide, attached to the front of it. I just copied it to give you some kind of flavor for what actually you're giving the person the right to do. So you can see there in that second paragraph, this document gives the person you designate as your agent the power to make healthcare decisions for you. Your agent must act consistently with your desires, except as you otherwise specify in this document. This document gives your agent the power to consent to your doctor not giving treatment or stopping treatment necessary to keep you alive. So again, know that you're giving that person essentially the right to, if you can't do it for yourself, you're giving that person the right to make a decision for you that might end up stopping medical treatment. So be sure that you pick someone that you trust. The next slide gives you a different kind of example of a limited power of attorney for healthcare, and that is for everybody who's got minor children. You can do a limited power of attorney for healthcare consent for minor child, like if you have grandparents or if you have an adult child, and then you've got some minor child, and you want the adult child to be able to make those kinds of decisions, or if you've got a brother or sister or somebody else, that a good friend that you trust, and you're going out of town and you need to make sure that that person's got the authority to consent to medical treatment on behalf of your child, then you can use this type of power of attorney called a limited power of attorney for healthcare consent for a minor child. We actually have statute that I've given you a small quote from there that that shows how this thing works, which is the legislature it doesn't have as many lawyers in it as it used to have, but it still has quite a few lawyers in it, and they have a whole staff of lawyers that draft statutes. So they like to use words like unemancipated, which doesn't mean anything much to anybody except lawyers anymore. It just basically means a minor child, a child who's not over 18. It also means one who hasn't been to court to be emancipated and declared an adult before they reach their 18th birthday. But that's not really something you need to worry about that much. The point is, if you've got minor children, there's a specific tool that's available to you, which is very simple. The form that I use when people want me to do this for them is just, it's one page of wording and then a second page where the people sign. The total document is only two pages long, and it's not a significant cost. I generally charge people $75 for something like that. It's just a form where we have to fill in the names and give it to people. So if you've got minor children, that's a very good tool. The next thing is this, in the next slide is this thing called the living will, which we were talking about. And the living will is different than your property will. I'm going to call it living will and a property will. A property will is a will that says, when I pass away, this is what I want to happen to whatever I own. That's a classic will that you've probably thought of, and lots of you probably have that. A living will is a written statement about what you want to happen if you're in certain conditions. In other words, you have permanent unconsciousness, or you have an inability to feed yourself. Do you want the doctor to give you CPR? If you're permanently unconscious and you have a situation where you need CPR to survive, do you want the doctor to give you CPR? Do you want life-saving measures to be taken? If you're permanently unconscious and you can't feed yourself, do you wish to have a feeding tube? Do you wish to be fed intravenously? That's what a living will does. It gives you an opportunity as an adult, a grown human being, to sit down with your lawyer and say, okay, here are the things that I want to do, and here's the way I want to be treated if I'm unconscious. And you write these things down in a living will, and then if that situation ever arises, the person shows that to your doctor, and they're bound by law to follow your wishes that are set out in that document. It gives you the opportunity to control your medical care at a time when you may not be able to speak and express how you want the course of your medical treatment to be conducted by your providers. Now, the next slide will show you something that's very interesting. Back in 2004, the legislature thought that lawyers were making too much money off living wills and healthcare powers of attorney. So you all can laugh privately at my joke. And so the legislature said, okay, we're going to do away with living wills and healthcare powers of attorney. And you can imagine that there was a big fight among lobbyists, including the lobbying arm of the Tennessee Bar Association. And what we got then was we kept healthcare powers of attorney and living wills. But now the Tennessee Department of Health publishes a form called an Advanced Directive for Healthcare. This document combines a healthcare power of attorney and a living will into one document. And it's 2 pages long, and I've given you the website there where you can download this thing. You do not need a lawyer to fill this thing out. You do need either a notary public or 2 witnesses to witness it when you sign it. either or. It's got a space on there for both of them, but you can do it with two witnesses who aren't notaries public, or you can do it with one person who is a notary public to get this form done. And it's freely downloadable in PDF format from the Tennessee Department of Health website. However, like so many things that are promulgated by bureaucracies, it is just a bit confusing. So I often end up giving people advice and explaining this thing. We're going to take a quick look at it because I know that a lot of people, just because of inertia or because of time constraints, excuse me, won't want to go to a lawyer's office to get this done. And I want to let you know that you can get a lot of this done without a lawyer, because you can download this healthcare form right from the Department of Health website, fill it out in your own home, get somebody to witness it, two people, you sign it in front of those witnesses. Be sure that's important to sign it in front of those witnesses. And then it should be effective. So let's go to the next slide, please, and I'll show you what the form looks like. Oh, sorry, it'll be the next one. Okay, so it's kind of hard to see that, but my email was at if you can download this thing directly from the Department of Health, but my email's at the first of the presentation. So if you have any trouble downloading it, email me or email Sandy or Jeanette, and we'll get you a copy of this form. But basically, this has two parts. Number one, you're going to appoint somebody as your healthcare agent. This top part, part one, up here, I can't control it. So the part up there that says part one, yep, that part right there where Jeanette's cursor is circling now. That part is the healthcare. Excellent, thank you. That's the part that replaces the healthcare power of attorney. It just basically says, I want the following person to make healthcare decisions for me. This includes any healthcare decision I could have made for myself if able, except that my agent must follow my instructions below. And then it has a place for, and by the way, it only has one space there for a name, but sometimes I have people who want to appoint, like they've got 2 children or 3, and they want to appoint all 3 of their children to make these decisions. I just write in that space where it says name, I write multiple names are listed on the attached sheet, and I write the names, addresses, relationship, and telephone number on that sheet, and then I have the person initial it, and I have the witnesses initial it, and I staple it to this form. So even though it only has one space, it does not mean that you can only have one person. You can have more than one person. That's perfectly legitimate. You just have to either put it on the back of the form, or you have to put it on a different page and attach it. Also, you can have an alternate. So if they can't contact the first person, they can get in touch with the second person. That's an alternate agent. And again, just because there's one space, you can have more than one person. You just have to attach it. Now, part 2 down there is the part that replaces the living will. Excellent. There we go. Part 2. That's the part that replaces the living will. And it's the part that says, this is what I want done if I'm in one of these states. Now, this is where I think it gets confusing, but I'm going to try to explain it to you a little bit so that you could download this form and do it yourself if you wanted to. Basically, think of it this way. It's a matching game. So that first condition is permanent unconscious condition. I become totally unaware of people or surroundings with little chance of ever waking up from the coma. So, okay, if you mark, this is satisfactory to me, yes or no. So by marking yes below, I have indicated the conditions I would be willing to live with if given adequate comfort care and pain management. So if you mark no on that first one, permanent unconscious, let's say you check no, then you have to match it to each one of these things down here. So if you mark no on permanent unconscious and you mark no on CPR, then, for example, your doctor will not administer CPR if you're permanently unconscious. If you mark no on life support or other artificial support, then, for example, you will not be given the treatment of a ventilator if you are permanently unconscious. So here's the basic way this thing works, even though if you're confused by it, don't worry about it, because I think everybody I've ever done this with or for, it's been confused. Everything where you mark no at the top, they're not going to do if you mark no at the bottom. So that's basically the way to understand that. Then the next page of this form, which is on the next slide, you have an opportunity to write in there that if you have some special instructions like hospice care, burial arrangements, you can
Hey, it looks like we're seeing some technical difficulties. Give us just a moment. We'll get back up.
Okay. Hey, Jeanette or Sandy or somebody, can you hear me now?
Yes, we can.
Okay, so I'm sorry. The video conference system in my office that our fancy video conference system just crashed. So I'm now back on through my iPhone. Okay.
All right.
So if you have any trouble seeing me, I've got can you see my face?
Yes, sir.
Okay, good. I'm trying to get this phone situated where I don't have to hold it. Okay, so we were talking about part 3 where you can put in your special instructions if you want to. And then in part 4, I don't know, if you've ever noticed, but when you renew your driver's license, you can make your preferences known about organ donation on your driver's license renewal application. I've done that, for example. You can do that, but you also can make it known on this form in part 4 right there. So you can say what you want done with your for organ donation if you want to do that right there on that form. And then there is the place where you sign it. Now, I reiterate again, if you're going to try this yourself, okay, do not sign it unless you've either got 2 people sitting there watching you sign it who are not notaries, or you have one notary in block B who's going to sit there and watch you sign the document. So you use block A if you're going to use 2 people who aren't notaries. You use block B if you're going to use the one person who is a notary. Now, this thing is, I think, great. And I think the legislature did a good service to the state of Tennessee by having the Department of Health put out this form,
because a lot of people who might not otherwise do it can go there and download it directly and do this themselves. Every time somebody comes to my office and does estate planning, we do a will. We talk about other things that might need to be done. We do a general power of attorney. We talk about healthcare power of attorney. We talk about a living will. And I provide this form to everyone who comes through my office in order that they can do it too. It does not hurt to have both a healthcare power of attorney, a living will, and this form also filled out. I recommend that to people all the time. In fact, I think it's a good idea to have both of them. Just make sure that what you've said in those documents is consistent and won't inadvertently create some conflict. So that is the healthcare form. Now, remember, this form is only for healthcare. It does not deal with your general business, with your banking, with your taxes, with your real estate, your other business transactions. You have to have a general power of attorney in order to do that. This healthcare, this advanced directive form will not take care of general business matters. Doesn't give the person any authority to do general business matters. The last thing, the next thing, and which will be our last thing on the last slide, is sometimes people run into a problem where once they've given one of these documents to somebody, the person turns out not to be as trustworthy as originally they thought that they were. And so what happens if you want to get rid of it? Getting rid of it is technically called a revocation. That's what it's legally called, revocation. And here are a couple of pointers for revocation. Number one, do it in writing. And by doing it in writing, I just mean that you would say, take a piece of paper and write out, I, Lewis Jenkins, am revoking the power of attorney or the healthcare power of attorney or the appointment of healthcare agent on the advanced directive form that I gave to John Smith on March 11, 2021. This document will not be effective from this day forward. And that is all it doesn't, and there's no magic language, by the way. I just made that up while I was sitting here. It does not matter. There's nothing magic about it except saying that it's over with. Do it in writing, sign it, reference the original document by date, and then give a copy to anyone who has the original document and anybody who has accepted the document to be used. Now, there are certain circumstances where a copy of it will need to be recorded in the office of the Register of Deeds, but I'm just telling you that as a pointer. You need to talk to your own lawyer about that, because that person can explain to you the circumstances under which it would be necessary to record that document in the office of the Register of Deeds. That's really beyond the scope of what I'm doing today, which is just trying to introduce you to the different types and scope of powers of attorney and living will. So the last thing I'm going to do is just take 2 minutes to go back and give you an overview of what we've talked about. Number one, we've talked about what is a power of attorney. That is a document that gives someone else the authority to act on your behalf, whether it be for general business or whether it be for healthcare. What is a living will? A living will is an expression of your desire for how the course of your medical treatment should proceed if you're not able, because of incapacity or legal incompetence, to express that desire to your medical providers at the time that the treatment is needed. Powers of attorney come in different flavors. We've talked about basically 3 different kinds. The durable general power of attorney for regular business like banking and real estate. The limited durable power of attorney for specific transactions like the closing on one house or a specific loan transaction or something of that nature. It's just limited in scope and it doesn't extend beyond those specific transactions that are actually listed in the document. And then we've talked about the healthcare power of attorney, or the durable power of attorney for healthcare. That gives the person the right to make those decisions for you in the realm of healthcare. And remember that if in the healthcare realm, the power of attorney only becomes effective if you can't make the decision yourself. In the regular business realm, the power of attorney is effective when you sign it, unless you make it a springing power of attorney, which says it only becomes effective on the occurrence of some future event or on some future date. And then, in addition to healthcare powers of attorney and general powers of attorney, we talked about the state advanced directive form, which you can download from the Department of Health website, which gives you the opportunity to informally replace what a healthcare power of attorney and a living will would do in a somewhat simpler format. And finally, we talked about how to revoke those things if you need to get rid of them. So I'll stop there, and I'll see if anybody has got any questions, or if there's anything that you need to ask me. And then if there's not, at the end of this, I'm going to turn it back over to Judy Long so that she can close out the program. Thank you very much for allowing me to be with you this afternoon. And I think Sandy gave you my information. So if you need to ask me a question and you don't want to ask it in the context of this presentation, you can certainly send me an email. I'll be happy to give you some guidance about how to get this stuff done in any way that I can. Thank you very much. So someone just asked a question. Can a power of attorney document give the attorney in fact the right to appoint another attorney in fact on your behalf? That is actually a very, very good question. And the answer to that question is yes, it can, but only if it does so specifically. In my form of a power of attorney, there's a line that says that the attorney in fact has the right to appoint other agents to assist the attorney in fact in accomplishing the business of the principal. And so the answer to that question is yes, it can, but it has to say so specifically. So if you're doing a power of attorney and you want that in there, you need to tell your lawyer or the person who's preparing the power of attorney document on your behalf that you want your attorney in fact to be able to appoint somebody else to help them, or that you don't want that. If it doesn't say anything, they won't be able to do it. If it says it, then they can do it. Okay? I hope that answers that question. Is there anything else? Any other questions? I'm looking at the chat here, and I'm sorry, I've got the phone tilted up at my face. I apologize. I know that looks weird, but I'm holding it so I can see the chat box. Okay, I'll turn it back over to Judy then. Again, thank you very much to everyone for letting me be with you this afternoon.
So Lewis, thank you so much for being with us today. We appreciate it. You've done a wonderful job, as was expected, of presenting the information. I know I've learned, and I have all these documents already prepared, so I may be reaching out just to make a few changes. Thank all of you for joining us today. If you have any questions concerning the program itself, we plan to post the program. I think we will have a link out to the program. It will be on our website. And so you can access that. You can access the recording as well as the slides. And we also will probably post on fcnb.com/smartwomen. So that you can go out and gather this information. So thank you for joining us. We will get back with you at a later date for our next program. And please give us some feedback as to how well you enjoyed this information, how helpful it was to you, and what would you like to see next in terms of our programs. We want to deliver the information that you need, that you feel like empowers you as women to make good financial decisions. So thank you so much. Appreciate you joining us today.
Thanks, guys.